Welcome to Disability Law for Railroad Workers.
Hello and welcome back to Disability Law for Railroad Workers with Roger M. Driskill. Roger is a disability attorney who helps people secure the benefits and steady income that they deserve, including railroad workers, Social Security applicants, ERISA claimants, and federal employees. My name is Kevin Rosenquist, and today Roger is sharing real case stories that show how persistence can turn repeated denials into disability benefits. Roger, good to see you again.
Good to see you. Thank you for this opportunity.
Why do you think real life case examples can be so powerful for people who are either considering filing or appealing a disability claim?
I think people by nature are storytellers and they want to hear the story of another person. It is a privilege to be able to hear the stories of people that have bad health and have had struggles in their job and be able to share that story and put it in the context of a disability application. When a story is presented to the decision maker, whether it's the clerk or whether it's the judge, when you can associate the life experiences and problems that that person has had with the medical records, with the tests, with the unsuccessful work attempts, with the troubles at the jobs that they've had, it's a powerful way to share what this problem has turned into for this applicant and how this applicant has met the qualifications to be entitled to benefits. It's a good moment when you can associate those and have a successful presentation.
I can imagine. Yeah, that's got to feel really, really good. Now, one of your clients, we're going to call SKH, was denied by the Social Security Administration more than once. Can you walk us through what happened in that case?
Yes. I'd like to tell you that every application is approved initially within a few weeks or a few months, and the applicant can move on down the road. On an occasional basis, and far too often, claims are denied at the initial level, at the reconsideration level, and even in front of a judge, whether it's a railroad judge or whether it's the Social Security judge. If we believe that there is medical evidence to support the application, or if we believe that the judge or the decision maker has made a mistake in not properly analyzing the facts or applying the law, we will appeal at every opportunity. The process for the disability application, whether it's Social Security or the Railroad Retirement Board, can take weeks, months, or years. And the appeal process is no different. And we will appeal. And in the case of the one that you mentioned, we went to the appeal council of the Social Security Administration, denied there. We went to federal court, got the federal judge to agree with us, and we got a second hearing, and this person was approved about 4 years after the initial application.
Wow.
The claimant got lost in the bureaucratic maze, and ultimately, with a second opportunity, a second hearing, this person was approved. I had a gratifying episode or situation this week. Again, we'd like to get everybody approved initially, but it doesn't happen. This week, I got a call from a lady who's still in her 30s. She's been a client of ours for over 12 years. She had a very serious injury when she was in early 20s. She's bright. She had good education. She had a good work history up until she was injured. And she looks healthy. We had 2 hearings with her. We got, those were denied. We got reversals in federal court twice. And finally, earlier this year, she was approved. Her back due benefits are over $150,000. Her share.
Holy cow, that's nice.
But it took 11 years. And so I'd like to say that everybody believes us the first time, but persistence is required. And sometimes cases are lost and have to be refiled. It's very discouraging. People want to give up. They're they're frustrated that they're not believed, but persistence is sometimes required. And we urge people not to give up when we believe that there's a factual basis for their claim.
Back to the SKH case, what problems did the appeals council finally find with the judge's decision that led to the claim being approved?
In that case, the judge, the Social Security judge, had not properly evaluated some medical records. Medical records are for healthcare people, and judges are attorneys. And it was our position that the judge did not give proper consideration to the resulting pain and limitation in the range of motion of this person. If a person has an MRI that says that they have mild or moderate problems with their disc or their neck, that should translate into a belief and an expectation that this person cannot move their neck, cannot move their arms, cannot sit properly in a work setting. And this judge indicated that, well, she couldn't do her former job, but she could do a different job. And the appeals council agreed that our position that these MRIs and these EMG records supported limitations in the use of the arms and the neck and the inability to sit in a sustained position merited an approval. And the Social Security judge in the first decision saying, well, this person could still do a sit-down job, there was no factual basis for it.
It's amazing to me that so many people could read it wrong. You know what I mean? There were so many people in the process that eventually it got approved. Is it just simply like what you said, that these people aren't doctors, so they don't understand the reports the same way?
We see that far too often.
Mm-hmm.
So it's very frustrating. But the medical records, we believe, are very straightforward, but it is far too common for a decision maker to discount medical records or hang their decision on something else that's extraneous, used as an excuse to deny a claim on a matter that is really not that important or not that relevant.
So I want to talk about another case that you had. We'll call this person JMT. Their case was denied multiple times. What were the challenges in this case, and how did that play out?
Well, the challenge is getting the people on the appeal process, the appeals council and the federal judge, to agree with us that the Social Security judge had improperly denied the claim. And in that particular situation, the judge had misstated the law. Social Security law is not concrete. It changes regularly. And this judge used the wrong law, the wrong time period, and that was a good ground for an appeal, and it was ultimately successful. But another challenge is the time delay. The appeals system, the court systems are clogged with lawsuits. There's not enough judges to go around. There's not enough appeals people to go around. And so the delay is extremely frustrating. That particular client was broke, did have some family help, but this person had to move around from relative to relative to relative with no money, no resources for a very long time. This client did stick with us. It's very frustrating when your lawyer calls you up and says, we got another decision that we believe is wrong and we want to appeal. People don't like to hear that. They shouldn't have to hear it, but it's reality. Mm-hmm. So the client stuck with us, and ultimately the claim was approved. This person now has some peace in their life and knows that there will be food on the table when it's time to eat.
That's great. How important were the medical opinions from JMT's treating doctors in getting the benefits approved?
It's critical. When we were going into the appeals process, we went back to the primary care doctor and pointed out how the Social Security judge was mischaracterizing the result of the tests and mischaracterizing the consequence of these symptoms and these diagnoses. So we were able to get the primary care doctor to address these problems. Another hurdle, not in this case, but it's very common. Doctors, nurses, specialists go to school to help people get well. They're not in the business of helping me get evidence on a disability claim. So when you can get a primary care physician to support a long-term patient, my client, and go to the trouble of addressing mistakes by a judge, it's very helpful, and it was a difference maker in this case.
Wow. So after years of denials, you finally got those benefits for JMT. What message do you think this gives to other workers who may feel discouraged in their own process? Are you able to use these stories to help kind of like, I don't know, get some more energy into people to continue the fight?
Well, we don't share client information with other people, but we do encourage people to please pursue this application when we believe there's a factual basis for it. On occasion, the client gets better, and we encourage them to try to work if they can. There are resources called vocational rehabilitation. Each state has one. If a person says, well, I can't work, I don't know what I can do, and they've been denied, we encourage them to at least contact vocational rehabilitation and see if there's a job out there. But when they can't, we have done this business a long time, and when we believe that there's a case that should be pursued, we strongly encourage it. We don't want people to walk away, live the rest of their life with no hope when there is hope.
I can understand the frustration though, especially when claims keep getting denied and it just drags on and on and on, and you start to lose hope. How do you change that mindset? I mean, it's got to be hard for you sometimes when people are pretty convinced they want to stop to convince them to continue.
I appreciate that. We try to let people know from the very beginning, this claim is about you and not about us. And we try to stay in constant contact with them. When they call, we try to answer their question promptly as best we can. When we get good news, we share it. When we get bad news, we share it. And we try to put that in context. Mm-hmm. You know, if a person gets an initial denial, very discouraging, very frustrating, but we let them know that there's appeals processes, and we believe that there's a path or an avenue for a successful claim. And we also try to determine, well, are there other steps we can take to develop evidence? So further communication with the client might open up a door for us to try to get another piece of evidence. And so this goes back to the importance of the story. Try to revisit the story sometimes. Is there a former coworker or former supervisor or former neighbor who might be able to shed some light on a recent denial and show that there's no basis for that denial?
Is it a situation, I know in certain situations with insurance companies especially, that they might just deny the first one no matter what, just to see if people will go away. Do you think there's any of that involved here?
It appears to be.
Mm-hmm.
I don't work for the Social Security Administration. I don't work for the Railroad Retirement Board, so we don't get to see behind the curtain.
Sure.
And by and large, the workers in those agencies are very dedicated and very diligent. But we've seen enough situations where it sure is curious when situations like you mentioned do happen. Mm-hmm. So it's easy to speculate that way, but I'm not criticizing the agencies or the workers because I know that they take their job seriously.
In the case you mentioned earlier, the person that it took 11 years, I think you said, to get theirs finalized. What did that person? What were they doing that whole time? How were they keeping afloat? Were they able to do some work?
No. In that case, not only did she not have any money, and not only did she have bad health, she had domestic problems. Mm. And lots of times people, when they walk in the door, they don't walk in from a vacuum. They've got family problems. They've got relationship problems. They got no end of problems. In this lady's situation, she had very supportive parents. If she hadn't had parents, I don't know where she would have been for those years because her domestic situation was horrible.
Oh, geez.
Uh, there is no end to what challenges people can have in this life. And again, that goes back to the importance of that person's story.
Mm-hmm. Oh, you've seen a lot, I would imagine, in your long in your long career.
I have, and I enjoy it. I embrace people, uh, and the opportunity to try to get them in the right path, in the right place where they're supposed to be in life, and get some peace in their life. And just because a person can't do their former job doesn't mean that they can't do something else in life. And so we try to get them in a position so that they can move on and go where there's another opportunity.
Mm-hmm. Well, you can definitely feel your passion to help people. People are lucky that people like you are out there advocating for them. I think it's very cool, Roger, and thank you for sharing those stories. Thank you for listening to today's episode of Disability Law for Railroad Workers. If you've been denied disability benefits and aren't sure what to do next, visit burnettdriscoll.com to learn more. And don't forget to subscribe to our channel. We got a lot of great information coming your way, so please stick around. Roger, really great chatting with you. Thanks so much for all the stories and all the insight.
Kevin, thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.